in the matter of the claimant in the Royal Mail Group Litigation and the Royal Mail Group Ltd.
Yes, Mr. Quadara.
My lord, I can't resist giving you the latest proofs of my learned junior's excavations. Thanks to Mr. MacDonald for this. He found the comments. I mean, this is purely background, but he's found some relevant comments from debate in the Lords in 1938.
Right.
And it's a miracle of the internet. If you could just turn to the back, we'll do law right first. I stress, it's pure background, not suggesting this ticks any of the boxes on Pepper and Hard or anything of that kind. Lord Wright, my lords, I do not wish to detain your lordships after what's fallen from my noble...
He was a member of the committee?
Yes, he was indeed.
He was the MR at the time, was he?
We'll check, but that could well have been, but I would need to... Yeah, we're checking. We think so, but we'll check. I desire to associate myself with everything he has said, and I'm sure you would all regret if either of us embarked upon a detailed examination of the very technical provisions of this bill. I only want to say one thing, and that's about the functions of the Law Revision Committee. The members of the committee do not desire or claim to dictate to Parliament what the law should be or how it should be altered. Their functions are much simpler. Their functions are simply to examine a particular question of law submitted to them, consider whether it's capable of improvement, and to make a report stating what, in their considered opinion, that improvement should be. I may say at once that the committee, a highly qualified committee, if I may say so, excluding myself, of course, spent many anxious days and weeks examining this question, but they are no more infallible than any other mortals. Their report is published and it's open to everyone to consider it. The report on which this bill is based has been before the country for a considerable number of months, and surely if it is to be criticised, if it has blemishes, it is for those who are concerned to point them out. We've done our best, and it's for Parliament to decide whether effect should be given to our recommendations and what form it should take.
Say that.
Another world. And Lord Roma, I won't read it, but a couple of pages, or a page earlier, Lord Roma comments, my lords, as a member of the Law Reform Committee, upon whose report this bill is founded, I would ask your lordship's permission to say a few words, etc. And he says 2 or 3 lines down, the present law on the subject is a mass of inconsistencies, of anomalies, of distinctions, where there is no material difference. And then he goes on to talk about something which is not relevant to our case. But I couldn't resist that. I don't know how much public debate there was about the bill in June 1938. However...
Well, the report was available for the princely sum of 9 pence
Indeed.
in 1936. So.
Quite a few bus rides, actually.
Yes.
So, my lords, with the benefit of the overnight thinking, I've distilled matters down to the following very simple approach, which is simply to demonstrate, hopefully, that Seguros and Ned Lloyd or UB Tiger are entirely consistent with each other, and thereby, of course, with Knox and Guy. So they're consistent with each other. All the relevant cases are cited, so in either case, for good measure, can it be said that they're per incuriam. So no conflict, no per incuriam problem, and of course, by definition, other than Knox and Guy, no input into the legal story from any higher court as at today's date. So there's no, so none of the potential Bristol aeroplane points are available, we say. So,
well, you say effectively that UB Tiger has explained Seguros. We're bound by the explanation. There's no statute which has been overlooked. There's no binding authority which has been overlooked. That's the end of that.
And yes to all of that.
What's more, it's right.
Yes, and I was just going. It's right, and really the only task I've set myself is very speedily, and I suspect your Lordship's way ahead of me, just to point out that they do apply the same test. In other words, they apply that double-barreled test. Is it an underlying purely equitable right? No. Okay, that's law. Therefore, we look at the remedy. And at the end of the day, it's the remedy-based test that was either passed or failed in these two cases. Failed in Seguros, because it was damages, 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 if I can quote from Lord Justice Waller. Make that good in a second. And it was passed in UB Tiger. So my approach will be simply to look at, just to point out, and I will do so speedily because these cases obviously have been considered in the course of the week. Can I invite, therefore, the court to look at Seguros, which is divided 10. And Lord Justice Waller, in his introduction, quotes from Mr. Justice Langley, Mr. Justice Langley, if one looks at letter D, has got a number 1, damages for breach. And then if we look below E, number 2.
Where are we?
My lord, it's introduction. I'm not seeing a
Page 114.
And 114.
Yes, I do apologise. I didn't realise we don't have the para numbers. So in that introduction, 114, there's the quote from the judge below, starting with the words by a generally endorsed writ. And the only simple point I'm making, this is my damages point. At D, number 1, Mr. Justice Langley says damages for breach of 4 written binding authority agreements, etc. Between E and F, number 2, damages for negligence and or breaches of duty or duties, etc. And at F, 3, damages for negligent misstatement and or etc. His Lordship takes that quote. That's all remedy based. And then, if one could turn to report page 117. And his Lordship's preliminary thoughts, and essentially in this paragraph, he 4 or 5 times he says what he would have expected, and what he is essentially doing in this paragraph is focusing on the underlying, forgive me, legal nature of the claim. So he says between E and F, I admit that my starting point was that I would have expected the rights and duties to be defined by contracts, etc. 2 lines down, I would have expected the obligation of fidelity of his to one principle as opposed to another to be defined by those terms. And he explains what he would have expected in the next sentence, and what he would have expected in G, and what he would not have expected at towards the end of the last complete paragraph, just by H. I would not have expected, in relation to a claim for damages or compensation for misconduct in the course of carrying out the pool arrangement, that there would have been any necessity to turn to equity for help. He then expresses satisfaction that Bousted doesn't turn to equity and doesn't mention, top of the next page, any equitable compensation or equitable damages as a remedy for breach. So his Lordship has positioned the analysis very clearly as one in which the focus, therefore, is going to have to be on the question of the remedy. And he turns to that. If we can turn the page to report page 119, and his Lordship is distilling at this point Lord Justice Millett's comments in the Mothew case. So at 119, between C and D, he comes to equitable compensation for breach of duty, and he makes the point that it resembles common law damages, and there is no reason why common law rules of causation, remoteness, and measure of damage should not be applied by analogy. It should not be confused, etc. So in a sense, at that point, the case is over, because his Lordship has said obviously we look at what follows. His lordship has said what he said about the legal nature of the underlying dispute and the rights, and at this point he essentially lines up the remedies as similar. And then if one drops down, still on page 119 to point 5, just above G, there's a para break. I accept that fiduciary duties do arise independently of contract, and that in situations where an agent is acting for two principles, as in the instant case, one principle has a cause of action for an intentional breach of fiduciary duty, independent from causes of action in contract or in tort. I also accept that historically equity might have provided either remedies that were restorative or remedies that were compensatory. Thus, I accept that sections 2 and 5 of the 1980 Act are not directly applicable and would reject the first submission of Mr. Gross. I also accept, as did Mr. Gross, that there is no reference in that Act to breach of fiduciary duty or dishonest breach of fiduciary duty. The answer to this appeal turns on whether, by section 36, sections 2 or 5 are to be applied by analogy. Just pausing there, the first submission of Mr. Gross, I passed over it, it's at 117B, and that was effectively doing battle on the underlying legal nature rather than equitable nature. And what his lordship has said on this page, the one I just read, is that doesn't get you home, and therefore we've got to look at the remedy. And that's pure Knox and Guy in my submission. And from this point on, as one can see, there's a heading towards construction at the bottom of that page, construction of section 36. His lordship is talking about remedies, and entirely consistent with the approach taken in UB Tiger. At the top of page 120, there is the obviously necessary gloss imposed on the Act that you don't look at to see whether it was in fact ever done, but whether, as it were, the legal culture was such that it would have been done. And then his lordship's discussion from the heading at the top of 120 onwards focuses, first of all, Knox and Guy, which we've seen. Then there is the Spry passage, and this has been misunderstood in my submission by Royal Mail, insofar as, and I may be wrong here, but if one looks at letter C, lower punched hole, there is this sentence, but if there is no such provision, the court may decide.
No, I'm sorry, I'm lost.
G.
G.
I'm
yes.
so sorry, my eyesight. It's G, forgive me. I do apologize.
Thank you.
So by G, within the Spry quote, but if there is no such provision, the court may decide that the material equitable right is so similar to the legal rights to which a limitation period is applicable that the limitation period should be applied to it also. End of quote. That phrase, material equitable right, is speaking of the remedy, not the underlying legal analysis. And just before I try and make that good, may I observe that that's a much clearer, bright line test for courts to apply, for advisors to apply, than any test based on sometimes the fuzzy boundaries, analytical boundaries between duties implied at common law, equitable obligations that arise in equity, and it's very striking in all these cases. The judges simply look at the remedy, they say, right, that's an account, that falls into one category, and these cases, speaking of specific performance, mandatory injunction, that falls in the other. It's a simple, bright line test. It may be offensive to the modern mind that while we're no longer ruled by the forms of action from their graves, that we are still somewhat ruled by the past in terms of the issues that we're dealing with, but that's where it was left.
So earlier in the passage at F, when the author is talking about abrogation of the right at law or statute that relates to rights at law, that's also remedies?
Yes. because it's the remedy that's barred by the limitation statutes. So I'm presuming that the word abrogation, I've struggled slightly with that sentence, but I'm presuming that's a reference to time bar. And if it is, then it's a reference to the Limitation Act, which in turn, the currency, as we know of our Limitation Act, is not to bar the underlying right, but to bar the remedy.
The passage starts by saying that the statute may be raised in defence to a claim that's brought in the exclusive jurisdiction of a court of equity, such as in proceedings for the enforcement of a trust rather than its auxiliary or concurrent jurisdictions. So what is the auxiliary jurisdiction? Enforcement of a trust, you can see, that's equity. There's no common law involved in that at all.
Indeed. I hesitate because that word is used, I think, in different senses by different commentators. My submission is that it's the sort of case, perhaps, that was involved in Seguros. I hesitate, but where you've got a principally common law claim and principally common law remedies, where someone tries to, I can borrow a phrase from my late friend, tack on some equitable remedy, for which there may or may not be a parallel. So in this case, it's the classic. There was some equitable financial compensation remedy.
Well, that would fit with the idea of auxiliary as being in aid of the common law.
Yes. Mm-hmm. My lord, that's me speaking, as it were. I decided not to trouble your lordships I've decided not to attempt to present the Beatson article to the court, simply because it's a great article, if I may say so. But the professor was dealing, the big message from the article is, it's chaotic. Everyone has their own view, you can find authority for anything, and I'm not quite sure how that helps the court decide the case. So I'm sticking to this thread of remedy. It's the remedy that is the key thing. But in that article, I think Professor Lewison does deal with nuances around auxiliary and so forth. But I think, if we move on, that it's made clear, either in this case or the next.
But you don't really need to persuade us that Ned Lloyd is right. All you need to show is that it's not obviously wrong. And if, as you say, Professor Beatson says, well, you can find authority for pretty much anything, the choice has been made by Ned Lloyd. That's the choice that this court made. It binds us. And if there's a different choice to be made, it's not for us to make it.
Well, indeed. My lord puts the bar attractively low for me in that sense. If I may say so, though, Ned Lloyd and Securus apply the same reasoning. Different outcomes, different stories. Let me return to Spry and say this, and come back to this material equitable right, and indeed the earlier part of that passage. As we'll see when we come to Lord Justice Clark, it would appear that Seguros read those references, as I'm urging upon this court, as references to remedy. There is perhaps a clue to what it means in the title of Spry. The name on the tin, as it were, is Spry's Equitable Remedies. And it's not a book on equity generally. And therefore, it may not be a profoundly analytical point that I just made, but it is some guide to what they're likely to have been talking about. And we'll see in a moment. I'm just going to go through the case sequentially, what Lord Justice Clark thought of it. I am reminded, just before I forget, that of course Professor Beatson did agree with the outcome in UB Tiger, but that's not, that's just an en passant comment that I should have made earlier. So I'm taking my learned friend's approach on the Spry passage head on, as it were. I ought to also say, still looking at page 120, that the part of the Spry passage on page 120, which starts just above G,
But if there is no such provision.
yes, but indeed, from the comma after the word provision, the rest of that page appears in the judgments in UB Tiger, plus the couple of lines over the page. So it's just a small factual point. I haven't noted which page it appears on, but that self-same page was in front of both courts, from the comma before the words the court may decide. So they're lined up, at least to that extent. They're further lined up to that extent. And then turning the page to page 121, just below letter B, his lordship records Mr. Gross as having submitted, he submitted, the distinction had nothing to do with whether equity was exercising its exclusive jurisdiction. And with that thought in mind, if one goes to 122 at letter C, his lordship concludes, in my view, Lord Justice Millett's treatment of Nelson and Rye demonstrates that point and demonstrates beyond peradventure that the question whether equity was exercising its exclusive as opposed to its concurrent jurisdiction does not supply the definitive answer as to whether equity applied the statute by analogy. And in the next sentence, he says, in Nelson and Rye, Justice Laddie held that the claims to an account in relation to fiduciary duty were outside the scope of the Limitation Act. But he didn't consider Section 36 and whether there should be any application of the statutes of limitation by analogy. So the implication, perhaps, is that had he done so, it would have been a different outcome.
But the problem with that is if you go on to see what Lord Justice Millett said in Paragon, which is quoted, action for an account is brought by a principal against his agent is barred by the statutes of limitation unless the agent is more than a mere agent but is a trustee of the money. The remedy is exactly the same. It's an account. It's the legal basis on which the account is sought, i.e. whether it's sought on the basis of a legal right or an equitable right, which dictates whether or not the statute applies.
Well, indeed, and
so the focus on remedy doesn't seem to be borne out by this passage at any rate.
well, my answer to that is that one gets two shots, as it were. In other words, I don't have that first shot because we're dealing with tort and legal remedies here. Had I had that first shot, then that might have got me home anyway. So it's in that sense, it's slightly asymmetrical. But so I'm guilty, focusing as I do on remedies, of not having made that clear. That's the only shot. I've only got two shots. The first one doesn't go off. So that's, in my submission, the explanation. Lord Justice Millett matter. I mean, there's no case to think of where there was a truly, purely equitable right which has been dragged into limitation because the claim was for damages or something of that kind. So if you can show its equity, great, you don't have to go any further. But if you can't, then you hang by the thread of the remedy point. and that's where we are in this case. And indeed, that's where the courts were in both Seguros, which at the end of the day, purely commercial dispute, and Ned Lloyd, which was all about containers, again, a purely commercial dispute. And it's, if I may say so, striking that certainly the commercial judges in the story, some of them, do appear to find this entire exercise somewhat constraining. Lord Justice Staunton wakes us over the page where he indicates great dissatisfaction that we're having to do any of this at this stage in our history. But just to jog back, so what I did was try and link up the submission by Mr. Gross with the acceptance, and it's a whole question of concurrent or not concurrent. It isn't where you find the answer. Just to go back for a moment, if I may, to 121 at D to E, his lordship there's a sentence which starts, furthermore, it's really just between D and E, furthermore the claim is one for damages. The inverted commas, we understand what his lordship's thinking at that point. He goes on to say, the prayer for relief has now been amended with our leave to add a claim for equitable compensation. But the reality of the claim is that it is one for damages, the assessment of which would be no different whether the claim was maintained by as a breach of contract claim or continued simply as a dishonest breach of fiduciary duty claim. So pausing there, that's again the Knox and Guy, the second barrel, as it were, the remedy-based approach. So then turning, and so I've done the major work here, if I may say so. His lordship's conclusion on page 123 at D, or his conclusion, he approves Mr. Scher's comments in Coulthard, and at G we see that Mr. Scher, QC, was speaking, he says, but secondly, even if the relief afforded by the Court of Equity was wider than that available at law, the Court of Equity would apply the statute by analogy, where there was correspondence between the remedies available at law and equity. So Mr. Scher is with great respect, him in the right place. And then Sir Christopher Staunton complains at just about F, still have to go through these hoops, having agreed with Lord Justice Waller. Lord Justice Clark, over the page, at 125, he also agreed with Lord Justice Waller. He becomes remedy-centric, if I can use that ugly phrase, at the top between A and B, and similarly, I don't think there's anything more on that page. But then, to come back to the question of Spry, at 126, at C to D, to adopt those words of Spry, there is a sufficiently close similarity between the exclusive equitable right in question, namely the claim for compensation for breach of fiduciary duty, and the legal rights to which the statute applies, namely the claim for damages for breach of contract founded on simple contract and the claim of tort for damages for breach of duty, that a court of equity would and will ordinarily act on the statute of limitation by analogy. There's nothing in the particular circumstances of the case to make it unjust to do so. On the contrary, it is just to do so because there is no reason why, if the claims for damages for breach of contract and tort are time barred, the claim for damages for fiduciary duty should not be time barred. So that disposes in my submission of any possible misreading of Spry.
Why doesn't the same apply to this case? The answer is UB Tiger.
Oh, indeed. Yes. So sorry, I hesitated for a moment. Yes.
But for UB Tiger, this would seem to point to an opposite conclusion.
Well, with great respect, my lord, no, because in the non-equitable sphere we seek damages. In the equitable sphere we seek. I'm grateful for the question. I must keep the answer short.
Mm-hmm.
We seek the production and handing over of an asset which has economic value, which we will then take away and deploy against HMRC.
But it's based on the same breach of the same duty at law.
Indeed, but it's a radically different non-concurrent.
Radically different.
And non-concurrent remedy that we seek.
Non-concurrent.
Well, suppose that somebody, leave aside Land Registration Act, somebody goes into possession of land
Yes.
and sits there for 12 years. You say that the court can grant an injunction telling him to stop his trespass, even though he's been squatting there for 12 years and the limitation period at law has expired? You can't claim possession, which is a legal remedy, but you say, oh, well, you can have an injunction.
Well,
Do you?
if you can claim possession as a legal remedy,
Yeah.
then I can see the argument that my lord is putting to me.
Well, you can't. I mean, let's suppose you can't, because the right to claim possession is barred. But on your analysis, you can nonetheless have an injunction.
Yes, and that has to be the logic.
Really?
Well, if only the only coercive remedy is an equitable remedy, and there is no correspondent remedy.
Well, yes, there isn't, because statute says you can't bring your possession claim.
Then we're into the world of equity. But while, as it were, from a modernising point of view, one sees the force of questions put to me, can this be right? Equity has developed all the appropriate tools to ensure, leges, for example, that justice will be done. And in a sense, I'm reminded that possession is, in some sense, is equivalent to a specific performance. It is...
Sorry, I don't understand that.
Well, in the sense that you're saying, do this, and hand back my asset, or complete.
Remove yourself from my asset.
Indeed. That is...
Stop your trespass.
In our legal tradition, it would seem that can only be done through an equitable remedy, which has no apparent parallel.
Well,
And
that's surprising, I must say.
Possession
Because you can take possession of land without the paper owner knowing anything about it. Time will still start to run. So leges wouldn't work, because the paper owner says, well, I didn't know anything about this. I haven't been sitting on my rights. But nonetheless, you say, it doesn't matter how long the trespass has gone on, it's still capable of being restrained by injunction.
I do. In a sense, that is the essence of the submission.
Yeah.
That the courts have said, in purely equitable situations, in situations where there is only an equitable remedy, then you have to operate the equitable approach to limitation and barring.
The trouble is that the injunction would be precisely equivalent to an order for possession, which you can't have. And therefore it wouldn't be granted by analogy.
Well,
I mean, it wouldn't,
yes.
frankly.
Otherwise, people
So
would
be
be
it.
doing it all the time.
So be it. I mean, if there is a...
But your point is, of course, that although you hope that the monetary value of one remedy as against the other would be equivalent or corresponding, in the sense that the damages claim is a claim for damages suffered by the loss by not having the asset.
Yes.
So if you have the asset, you don't need the damages, and the asset is something that is of value in relation to a third party, namely the revenue, they are corresponding and, in some senses, equivalent remedies based on the same right, which in one case is barred and the other case you say is not.
My Lord, save that I would submit that they are quite different. One is a remedy which leads on with the asset.
Yeah, of course.
We say goodbye to Royal Mail. The other, obviously, is profoundly different in terms of what we have to prove, indeed. We have to prove causation, loss, all those matters that we were discussing the other day. And we get a different thing. We get, theoretically, we get money. So they are genuinely different. I'm sorry I can't say more on the possession point. I've said everything that I think probably one could say. So I just want to take a moment. I'm going to leave that case. Just spend a moment with Mr. Justice Coleman, if I may, invite your lordships to do so. That's the next divider. And once again, perhaps one has the view from the commercial court here. Well, there's no perhaps. One does have the view of the commercial court and its distinguished commercial judge. And it's three paras, 24, 25, and 31. 24 is on page 3741. His lordship quotes Spry. And then at 25, he notes that passage was approved in Seguros. I've said 31. En passant 27, his lordship indicates a certain degree of understandable disquiet, as it were, at an intellectual level, perhaps, situation. And then what he says at 31 is obviously what was then reversed. And he says, having considered the authorities referred to both in Spry and Seguros, I've reached a conclusion that a claim alleging breach of contract and claiming specific performance and or damages and or an indemnity should be treated as entirely time-barred if brought more than 6 years after the breach relied on occurred or commenced. And then the critical sentence, whereas there is an intrinsic dissimilarity in the remedy in equity from that at law, the underlying facts are identical, and there is no question of any equitable right to property or anything in the nature of a trust being involved. The essence of the matter is that a continuing breach of contract is alleged, for which damages are claimed, and in relation to which the granting of the equitable remedy will simply put an end to the continuing accumulation of loss. In such case, the function of that remedy is to diminish the loss which would otherwise sound in damages. To conclude that the availability of this remedy went on existing, leaches apart, beyond the time when the claim for damages or indemnity or declaration of right ceased to be available, would be to contemplate such an implausible remedial facility as to suggest most strongly, that no court of equity would have so proceeded before July 1940. And there are, if I may say so, traces in the discussions that we've had just a few moments ago of that viewpoint, which, with great respect, one can fully understand. That was then reversed, as you know, and I'll take Ned Lloyd quite briefly, and I propose just to, that's divider 12.
Just as a matter of interest, procedurally, how did Mr. Justice Coleman's decision come before the Court of Appeal? It was an appeal from Mr. Justice Tomlinson refusing summary judgment.
Yes.
Why wasn't there an issue estoppel between the parties relating to the...
I'm just checking the dates. June 20.
I mean, I think Lord Justice Moorbick does somewhere say that Mr. Justice Coleman's order is set aside.
Yes.
But I'm not quite sure how it got there.
We'll have a quick think. Have a ponder.
I think that is covered in
Is it?
Justice Morbick's judgment.
21. 21. I'm told para 21.
21, thank you.
Thank you. Grateful.
Yes.
Go on.
Yeah.
The judgment has been set aside, although that the judgment by which it was set aside didn't say anything about this particular point.
Ah, yes. It's swept away collaterally, I think.
Oh, I see. I see. It was reversed on other grounds.
Yeah.
Yeah, right. Yes. Yes, it's 12. Para 12. So, Mr. Justice Coleman was reversed on a different point, and his order was set aside. Yeah.
So,
Thank you.
So I'm just going to be quite rapidly stating the obvious, if I may, which is that, just trying to filter out. So at para 38, Lord Justice Morbick, he's quoted Knox, Paragon, and then at 38, in the second sentence, just above G, he says, however, even if the limitation period doesn't apply because the claim is for an exclusively equitable remedy, the court will nonetheless apply it by analogy if the remedy in equity is correspondent to the remedy at law. In other words, where the suit in equity corresponds with an action at law, the Court of Equity adopts the statutory rule as its own procedure, and the words of Mr. Justice Coleman at 31, which I just read out, come to mind, where he speaks of the intrinsic dissimilarity of the remedy in equity and that at law. So that's the other side of the coin of correspondence. They then deal at 39 with de Seguris. So, and in my submission, there's no misunderstanding of de Seguris. We've been through it, so that takes us through to para 43, where Lord Justice Morbick then returns to this remedy-based theme, just a couple of minor quotes. It is not that 43, just above D, it is not surprising that equity should apply by analogy the limitation periods applicable to claims at law for an account and for damages, for breach of duty, whether in contract or tort, to claims for an account and for equitable compensation. In each case, the same facts give rise to a claim, whether at law or in equity, and the same kind of relief is obtainable. The claim for specific performance raises different considerations, however, both because relief is comparable to that available from the courts of equity, both because relief comparable to that available from the courts of equity was not available from the common law courts, and because the facts needed to support a claim for specific performance are not in all respects the same as those necessary to support a claim for breach of contract. There's Hasham and Zanab, which is mentioned, which we've made available. Jumping down to 44, the fact that the common law courts could not grant a coercive remedy comparable to a degree of specific performance strongly suggests that there's no case in which, to use the language of Lord Westbury and Knox, quote, the remedy in equity is correspondent to the remedy at law, or the suit in equity corresponds with an action at law. And then his lordship goes on to say you can find cases where the factual substratum may be the same. And that is the core reasoning in my submission. And just seeing as they deal with Mr. Justice Coleman at 46, having done that at 48, his lordship, just below letter D, his lordship returns to the theme of the absence of a corresponding legal remedy, making it impossible, in his view, to say either that the remedy in equity is correspondent to the remedy at law, or that the suit in equity corresponds.
Sorry, where are we?
My lord, forgive me. It's 48 on
48.
page 2308
Yes, yes.
and D&E. He then quotes the Spry passage, which we've seen, and again at 52, I'm just looking for anywhere where his lordship indicates what his focus is. So at 52 on page 2309, he's speaking again of the nature of the remedy, what it is, etc.
And not to the underlying right.
Indeed. And as I said earlier, at least it has the benefit of being a bright line test, which is not difficult to apply. He mentions at 2310 at B, he makes the point which I've made. He acknowledges the powerful arguments at the top of that page put forward by Mr. Justice Coleman. At B, he says, moreover, with all respect to the judge, this is not, in my view, such an implausible position, when one bears in mind that in general, under English law, limitation bars the remedy and not the right itself.
Yeah.
So I'm virtually done, my lords. So I say that cases that there really isn't any difference of approach between those two Court of Appeal cases. They're in the Knox and Guy tradition. Given, just on the possible point, which I don't think has ultimately surfaced, i.e. any possible analytical differences between injunctions and specific performance, that's not a point we come prepared to assist the court on, so I leave that there. Those subject to any questions, those are our submissions.
My Lord, my Lady, can I deal first with the reply to Leonard Fenn's submissions on the UB Tiger issue, and then, if I may, say a few words about going back to Leonard Fenn's reformulated case, which I having considered
The duty.
Indeed, the duty.
Yeah.
I can conveniently deal with now rather than putting in
Whenever you like.
subsequently.
Yeah.
Get quietus in terms of our submissions
Yeah.
on the issue. So, my lords, in relation to UB Tiger, I've already set out in detail by analysis of Spry, Seguros, and UB Tiger how we say what we say is that is a patent misunderstanding by Lord Justice Morvick in applying the test which he applies came about, and I'm not going to go through that analysis again, because in my submission, nothing in Mr. Cordara's submission engaged with that core submission. I'll pick up some of the specific points he made, but that point remains untouched. Can I clear away some of the detail first, and then come to that central point? Picking up some of the points that Mr. Cordara made yesterday first. He said early on, he sought to gain assistance from the fact that no cases have been discovered where the court has barred a claim for an injunction on the basis of section 36(1). But he accepted that wasn't actually the test. One must look at what would have been the position, not simply do an exercise of judicial archaeology and see whether any cases actually can be found. But he said, well, nevertheless, there aren't any, and that's perhaps significant, as it were, seeking to have his cake and eat it. As my Lord Sir Timothy Lloyd pointed out, it may be that it's going to be a relatively rare fact situation in which a claim for an injunction is going to be made more than 6 years after the cause of action, so that this issue arises at all. So I would invite the court not to place any significance on the fact that neither side's researchers have been able to discover any case where an injunction has been barred. Certainly not to suggest that the position was that it would not have been barred prior to the Limitation Act. Indeed, if anything, it should give the court the confidence evidence that this is effectively untrammeled ground in relation to an injunction, and puts some quite clear blue water between this situation and the specific performance situation which Lord Justice Morbick was dealing with, where there is a quantity of early case law which I think everyone is agreed is difficult to interpret. See the Beatson article. And
So I'm sorry, I think I asked you this at the beginning of your submissions on this issue. Are you saying we can distinguish UB Tiger on the ground that what the court was dealing with in UB Tiger was a claim for specific performance as opposed to an injunction?
Well, yes, I would say that, and I am, as I said, I hope I did say in answer to your lordship, I accept that that is not the way that our argument has been principally directed until now. But given that specific performance has now dropped out of the picture as a potential claim here, since this court has refused permission to appeal on that issue, I am now free, which I was not earlier, to make that submission. And I do say it's not the principle. We say this is a clear case where this court can have confidence that it should not follow the UB Tiger in any event. But I do also say that the route of distinguishing specific performance as a separate stream of case law, and given the importance which one can see in their cases to the courts following the particular remedial stream which is before it when looking at these cases. I mean, what I mean by that is that there is clearly inconsistency between different cases in different areas in relation to different remedies. The courts are particularly focused on the particular remedy available. And while I accept that Lord Justice Morbick's formulation on its face appears capable of application to any remedial claim before the court under section 36(1), clearly not framed in terms of being limited to specific performance. Nevertheless, that can provide a basis for this court to distinguish it.
Yeah.
Then
That's not your main point.
it's not my main point, Lord, but it is
a worthwhile point.
It is a worthwhile point, and it is there available. It is one route available to the court to deal with what we say is the very unsatisfactory position that the court appears to be left in if the position is that it has to allow the injunctive claim in these circumstances. The law commission analysis. Learned Friend made some submissions on the law commission tab 17 and
Law Revision Committee.
I'm sorry, the Law Revision Committee.
They hadn't thought of the Law Commission.
They hadn't thought of the Law Commission. Transposing it.
30 years to go.
Indeed, my lord. It's very briefly going back over that. The only paragraph which is said to be of relevance, as I understand it, is paragraph 13 on page 557. On a proper analysis, we say it really provides no assistance for Learned Friend's case as evidence of what the position was in relation to what matters in this case before the limitation. What one sees in the first sentence of paragraph 13, that's plainly dealing with cases where the equitable remedy is directly governed by a statute of limitation, the very extreme obedience situation. So that says equitable claims are in some cases directly governed by a statute of limitation, such as claims to land or rent charges. That is obviously right, but it's not our case. Then it says in other cases, such as specific performance or rescission of contract on the ground of innocent representation or setting aside gifts, no period applies.
So that's exclusive jurisdiction.
That appears, as indeed, my lord, to be exclusive jurisdiction. And it's a slight puzzle that it says no period applies. But obviously, if one's looking at what happens later in section 36, there will then, of course, be the inobedience test. But this is obviously before the change of law. No period applies may just be saying there are no limitation. He may be pursuing the first sentence. There are no statutes of limitation applying there directly. That may be what no period applies means. It's just saying, well, in other cases, that there aren't any statutes of limitation applying. and there may be late use. And then in the third sentence, it says, in other cases where a remedy in equity corresponds to a similar remedy in law, equity follows the analogy of the statute which applies to the corresponding common law remedy, citing Knox and Guy. Now, on the face of the test, equity follows, that favours us. And that is a formulation of inobedience. Equity simply follows the law. There is that leftover sentence, if a remedy in equity corresponds to a similar remedy in law. It doesn't appear to address what happens if a remedy in equity, if a remedy in equity does not correspond to a similar remedy in law. So, notwithstanding the eminence of the authors, the passage we submit is short, it's compressed, and is of little value as an indication of the law at the time it was written, beyond that very general gleaning. Then Knox and Guy itself. Learned friend tried to cast doubt on whether the decision is wholly in our favour by citing the words on page, drawing attention to the words on page 24 of the Bible, 674 of the judgment, in the judgment of Lord Westbury, in the middle of the page. And he notes there again, correspondent to the remedy at law point. I won't go over that passage, which I've already made submissions on, but I would ask the court to look carefully at the passage at the bottom of the page, which perhaps hasn't had undue sufficient prominence. This is last paragraph. If I can pick it up just above that, because Lord Westbury defines what he's meaning by analogy and obedience above that, just below the passage that we were looking at. So, starting off directly in the middle of the page, this is the meaning of the common phrase that the Court of Equity act by analogy to the statute of limitations. The meaning being that where the suit in equity corresponds with an action at law, which is included in the words of the statute, i.e. statute of limitations, a Court of Equity adopts the enactment of the statute as its own rule of procedure. In other words, it takes over the statute. But if any proceeding in equity be included within the words of the statute, there, Court of Equity, like the Court of Law, acts in obedience to the statute. So he's using in obedience here, in the relatively extreme situation of the legislation applying
directly applying.
Exactly, which is not the same, of course, in obedience. SPY has a much wider in obedience, and the way that I've been using it is in obedience applies where we're firmly in the equitable jurisdiction, equitable claim, equitable remedy. That then in obedience applies. And that's obviously, so in obedience applies effectively in two different situations. Firstly, if a statute directly applies to equity, of course you follow the statute, it's pretty obvious. But it also applies where you are in the exclusive equitable jurisdiction, where you have an equitable claim and an equitable remedy, and there, constant theme running through SPY, Theatre Seguros, etc. There also you apply an in obedience test and automatically apply the section 36(1) to bar the remedy, unless, except in the case of a fraud exemption.
I think part of the problem historically was that the statutes of limitation applied to actions,
Yes.
which were proceedings begun by writ,
Yes.
whereas proceedings in equity were begun by bill, and they were called suits. That's why Lord Westbury distinguishes between actions and suits. Where the suit in equity corresponds with an action at law, equity adopts the statute.
Yes, I see that. Yes, that's helpful. It's just been put to me, I inadvertently reversed the test in my the application of the test in that last submission I made. Of course, the inobedience test applies as well as in the case of a statute directly applying, not to the circumstance where we're in the exclusive jurisdiction. That is, of course, where you have to apply the equivalence test, because all equity, and we have to decide whether equity should follow the law. I reversed it in my head. The situation, the second in obedience situation, apart from the statute applying, is of course the situation where equity is stepping in as an auxiliary or concurrent jurisdiction to the legal, to legal rights, and that is the position where in obedience is appropriate, precisely because equity is doing no more than assisting the legal right, which is barred. If the legal right is barred, equity should act in obedience to the law and bar the remedy. I apologise. I must have confused the court by reversing it in my own head. But that is absolutely consistent with what Lord Westbury is saying, Knox and Guy. So we have acting by analogy in the statute of limitations where the suit of equity corresponds to an action in law. Then we have his definition of in obedience. And what I was leading up to, and slowly getting there, and I'm afraid confusing the court along the way, is then the paragraph at the bottom of the page. He says, "Your lordships will no doubt recollect that in the observations I have made with regard to the adoption of the statute by a court of equity, I refer to those well-known expressions of Lord Redesdale by which he distinguishes between the cases where a court of equity acts in analogy to the statute and where it acts in obedience to the statute, bearing in mind his meaning of in obedience above. Where a court of equity frames its remedy on the basis of the common law," now that must mean on the basis of a common law right. In other words, this is we're now talking about the auxiliary jurisdiction. Where it frames a remedy on the basis of the common law and supplements the common law by extending the remedy to parties who cannot have an action at common law, pausing there, cannot have an action at common law because it's been barred by the Limitation Act. There, the Court of Equity acts in analogy to the statute. That is, and then if there's any doubt, explains what he means by in analogy to here. That is, it adopts the statute as the rule of procedure regulating the remedy it affords.
Well, is that what he means by supplements the common law by extending the remedy? I wonder if he's actually talking about people who, well, I've no idea, but we're talking about the representative of a deceased partner who might not have an action at law, but might have a genuine economic interest, which might be assisted by a court of equity.
Well,
and then the question would be, if the right at law is still enforceable, then there's no reason why an added party shouldn't have the assistance of equity. But per contra, if the right at law is barred.
Well, I respectfully suggest that's not, certainly not the central focus of what he's saying. He starts off by saying where a court of equity frames its remedy upon the basis of the common law. So it does seem to me we are, in the first place, in a situation where we're dealing with a legal...
You're starting with a legal
right.
I just don't know what he means
Supplements the
by extending the remedy to parties who cannot have an action at common law.
Well, I took that to mean, why can't they have an action at common law? Because the whole focus of what he's dealing with in this whole page is situations where there is no action at common law because the common law action is barred by operation of the Limitation Act. That's why you're in the situation of considering whether equity is entitled to act or whether it's also barred by analogy under the operation of section 36(1). So that's why I'd taken him to be setting up there, extending the remedy to it. In other words, really extending the remedy means giving the equitable remedy, supplementing the common law by providing an equitable remedy to parties who haven't got an action at common law because of the barring. There, the Court of Equity acts in analogy. There, it adopts the statute as the rule of procedure regulating the remedy it affords. So certainly that's the interpretation which I invite you to place on that passage and provides a very clear statement from the House of Lords as to what equity does in the non-exclusive jurisdiction situation, which that it adopts the statute as a rule of procedure, and therefore bars the remedy where the claim is barred by the statute.
you.
Can I then come on to Learned Friend's analysis of Seguros and UB Tiger this morning? The first point which my learned friend made was that they do apply the same test. And he showed the court that both cases apply the same test. And in particular, the question of equivalence correspondence in looking at whether or not Section 36 Section 31 should apply, the proviso should apply. Well, that is absolute, and he makes the point that the test was failed in Seguros, but it was passed in UB Tiger. My lords and my lady, that is absolutely right, but it misses our central point, which is that the test was applied in the right situation, Sir de Seguros, but should never have been being applied in UB Tiger because the test didn't apply there. Point is that Sir de Seguros, being an exclusive jurisdiction case, you obviously do there look for equivalence or split correspondence. But in UB Tiger, it should not have been applied because per Seguros, we say Disco Mix, Noxby Guy, all the cases indicate that in the auxiliary concurrent jurisdiction situation, equity acts in obedience to the law, or, as Knox and Guy puts it, adopts the statute as the rule of procedure regulating the remedy it affords. And so the quite extended analysis that the learned friend did, showing the way the test was applied in the two cases, is in a sense not to the point, because it misses the fundamental point that where Lord Justice Morbick went wrong was to apply the test at all. Of course, when we get onto the test, he then reasons that there is effectively no correspondent remedy because injunction claim, no equivalent remedy not an injunction, specific performance claim, no equivalent remedy in law. And there is, as it were, a separate debate with Mr. Justice Coleman, as it were, not a debate, but a difference of view taken as to whether or not, when you are inside the correspondence equivalence test, where you should have come out in UB Tiger. But that is an entire debate or question which we say misses the point, which is that test we were not in UB Tiger, as in this case, we are not in the territory of that correspondence equivalence test at all. And it may be helpful to come to the passage of Spry cited in...
You say that the Court of Appeal in UB Tiger should have said, well, this is an auxiliary jurisdiction case, therefore the statute applies by analogy.
Precisely. And if I can take you back to Sir de Seguros, tab 10, at page 394 of the bundle, passage my learned friend took you to. He took you to the passage at G, but if there is no provision, the court may decide that the material equitable right is so similar to legal rights which a limitation period is applicable, that the limitation period should be applied to it also. And what he is pointing to there is Sir de Seguros applying the equivalence correspondence test. Quite rightly, we say, because that was a case of equity's exclusive jurisdiction. I'm sorry.
Wasn't the exclusive auxiliary point argued and rejected in Seguros? Wasn't that Mr. Flo's argument? I'm just looking at page 121. Now, Mr. Flo says the line to be drawn between those cases is 121F. Lines to be drawn between those cases where equity did apply the statute by analogy, and that was defined by the question whether equity was exercising its exclusive jurisdiction or its concurrent jurisdiction. And then Lord Justice Waller says that doesn't accord with the quotation from Spry.
But he says in the former case, Mr. Flo submitted, the court would not apply the statute by analogy.
That's to say exclusive.
And that is, indeed, the former case is exclusive. And that is what is rightly rejected.
Yeah. And then at 122
Yes.
C and D,
Yes. So,
he
yes.
says that Lord Justice Millett's treatment of Nelson and Rye demonstrates the question whether equity was exercising its exclusive as opposed to concurrent jurisdiction does not supply the definitive answer. So you say, well, if it's exercising its concurrent or auxiliary duty, then it always applies the statute by analogy.
Well, yes.
And even in cases of exclusive jurisdiction, it may still do so. That's how you put it.
Precisely. If the equivalence correspondence test is effectively not satisfied,
Yeah.
they're not equivalent, they're not correspondent. Yes. So that is precisely it. And the reason that Mr. Flo's argument is being rejected is because he's actually putting it the wrong way round.
Yeah.
He's saying the other way around. He was arguing that it was only in a concurrent jurisdiction case that you apply by analogy. It's actually the wrong way around. And the judge, and Roger Waller rightly comments, that is not in accordance with Spry. Doesn't seem to accord with the above quotation from Spry. Can I just come back to the passage on previous page that I was endeavouring to look at? I should have said, this is obviously a quotation from Spry that's being looked at, that's being referred to here. And the crucial passage that my learned friend was drawing attention to was the bit saying, but if no such provision, court may decide material equitable rights so similar to the legal right that limitation period should be applied also. So that's a description of the correspondent orthodox test. But what is clear if one looks just up a couple of letters on the page is that this is all in the context of the exclusive equitable jurisdiction. This is in the context where obviously the correspondence equivalence test does apply. And one can see at the beginning of the quotation, under Spry's equitable remedies, a statute of limitations may be raised by analogy in defence of a claim that is brought in the exclusive jurisdiction of a court of equity, such as here. There is no question of merely recognising and giving effect to the application of a right. You don't do it automatically. You don't, or acting in obedience. There's no question of acting in obedience to the statute that relates to rights of law. Here, instead, you then come on to describing the correspondence equivalence test. So this passage is absolutely in accordance with what we submit the position was, and was understood to be by Lord Justice Waller in Sierra Seguros. And so, and that is that is the issue which is not picked up by that distinction is the distinction which we say, for the reasons I've already submitted, is not picked up by Lord Justice Morbick in UB Tiger. My Lord Justice Lewison put to Mr. Cordara that effectively his case is the choice has been made by Lord Justice Morbick, by the UB Tiger. It's not for us to intervene. My simple submission and response is the choice was not actually made because, as we have explained, Lord Justice Morbick didn't appreciate the distinction between the test applicable to the exclusive equitable jurisdiction and the test with which he should have been concerned with in the auxiliary jurisdiction situation. It is not a case where Lord Justice Morbick, having considered the relevant authorities, took the view that a different line, that both tests, that the same test was applicable.
Well,
in that
UB Tiger is a case of concurrent or auxiliary jurisdiction.
It is
it's not within the exclusive equitable jurisdiction.
Indeed, my lord.
The case decides that the limitation period does not apply. So the distinction that you are drawing is rejected, or at least is not, is inconsistent.
It is inconsistent.
It's inconsistent with, all right, it's inconsistent with what this court decided in UB Tiger. So what gives us, this court, this constitution, the right to depart from it?
Because, my lord, the test that Lord Justice Morbick applied in UB Tiger, the equivalence test by which he reached the conclusion that they were not equivalent, he did not apply that test because he had considered the two streams of law and decided to take the court ought to apply the equivalence, the correspondence test, notwithstanding that he was dealing with an analogy case. He didn't consider the authorities and decide that was the line that the law authorised. He did so for the reasons that I've demonstrated, out of a misunderstanding that the tests enunciated in Seguros simply applied in this other category. There was no reasoning. It's quite clear that he cited authorities which quite clearly say there is a different test that applies in the two situations, and purported to be guided by them in applying the test to a situation where it wasn't warranted. So what one can see is what I submit. If your lordships are not with me that Lord Justice Morbick applied the test based on a misunderstanding, then obviously I can't persuade the court.
Well, suppose you're
either per incuriam.
Suppose you're right. He did misunderstand the test. That simply says that, well, the decision was wrong. I don't see how.
Well, my lord, in that event, no, my lord. Can I rely on? Can I hand up the Starmark Enterprises case, which your lordship mentioned yesterday, which actually, having looked at it overnight, is remarkably on point. If I persuade your lordship that we are in that actual situation.
Yes, I wondered if you'd get
Lord, Starmark Enterprises shows the Court of Appeal following an earlier Court of Appeal decision, AWAD Awada, where it is satisfied that a later Court of Appeal decision is wrongly decided. And it's significant to see the reason that the later Court of Appeal is concluded to be wrongly decided is because the later Court of Appeal misunderstood the earlier Court of Appeal decision, despite it having been fully cited to it and argued. And that is the basis. Taking you through it as briefly as I can, the main judgment is Lord Justice Kay. At paragraphs 11 and 12, he simply sets out the competing arguments. The landlord submitted that the decision of the majority in Mecca Leisure, this is the second case, the case that's alleged to be misunderstanding the law. Mecca Leisure was unsupportable, court shouldn't follow it, accordingly, etc. Tenant's argument was that, contrary to the argument advanced by the landlord, no conflict between the two Court of Appeal decisions, Mecca Leisure and Awada, and that Mecca Leisure is entirely consistent with the approach of the House of Lords in United Scientific. So there was rather like Knox and Guy, also a House of Lords decision sitting in the background that was said to be in conflict and misinterpreted as well by the later case.
In fact, a much more recent case in which the Court of Appeal, the subsequent Court of Appeal cases, were trying to understand what it, or purporting to apply what it had decided.
Indeed. And paragraph 14, Mr. Justice Neuberger had concluded that the decision of the Court of Appeal in Mecca Leisure was not inconsistent with Awada and therefore followed it. And can I then go forward all the way to paragraph 40, that's where Lord Justice Kay starts to consider Mecca Leisure, again involved the court considering a deeming provision. I won't go into the details of it. Various criticisms are made of the Court of Appeal's approach to this deeming provision by my Lord Justice Lewison. Paragraph 44 criticised this observation. First of all, 42, my Lord suggested that this represented a misunderstanding of the position because the landlord can serve a notice whether or not there's this deeming provision. Criticised observation by Lord Justice May. And 46, this passage reflects competing submissions in this case. Mr. Lewison suggesting that the second view should prevail, while Mr. Mail submits the first view is clearly correct on the authorities. And then, crucially, after consideration of detailed authorities, one comes to paragraph 62 and following. And one sees there the conclusion, Mecca Leisure, Lord Justice Everley simply dismissed the decision in Awada as being of no help at all, since it was decided on the wording of a particular lease which was different from the case he was considering. That, with respect, was to overlook clear point of principle with which the court was concerned in Awada, namely whether, and so on and so forth. The decision of Lord Justice May not to follow Awada in Mecca Leisure was, I believe, based on a fundamental misunderstanding of the judgment of Lord Justice Slade. For these reasons, I'm satisfied the approach of Lord Justice Brown-Wilkinson in Mecca. He was the dissentient, was the only proper approach that could be adopted. Majority read in a wholly artificial distinction led to many ongoing problems, and therefore, he concludes, with due respect to the court, in Mecca Leisure, concludes the case was wrongly decided. Having reached that clear conclusion, that it was wrongly decided, it follows the court's not bound to follow the decision. The court's bound to follow the earlier decision in Awada, applying principles emerging from the earlier House of Lords decision. And one sees Lady Justice Arden agreeing with that judgment, and Lord Justice Gibson delivered a concurring judgment I don't think I need to go to. It doesn't take a different approach. Well,
Lord Justice Peter Gibson, in '97, is the only one who actually even attempts to address in any analytical way whether this is a case in which the court was entitled not to follow the more recent decision.
So yes, I should have read that the first lines of that paragraph, where the ratio of an earlier decision of this court is directly applicable to the circumstances of a case before this court, but that decision has been wrongly distinguished in a later decision of this court. In principle, it must be open to this court to apply the ratio of the earlier decision and decline to follow the later decision. In my judgment, the majority of this court in Mecca wrongly distinguished Awada. Now, the fact situation is slightly different here, but I do submit that we are in precisely the same territory.
You say that what the Court of Appeal did wrong in UB Tiger was wrongly to purport to apply.
Exactly. Precisely. It wrongly misunderstood Seguros and wrongly thought, well, it simply follows it, we apply it. Yeah. But in fact, it should not have been applying it. It should have been reaching for a different test of it, the inobedience test. And the reason we say it is a clear misunderstanding is precisely because Lord Justice Morbick did not say, I've considered Spry and so on and so forth and the other authorities, but I'm striking out in a slightly different direction. I think this test is that instead I think that the equivalence test must be applied in my situation, the auxiliary jurisdiction. He didn't say that. Instead, he purported to apply. He clearly thought that the test he was enunciating was not inconsistent with Spry, Seguros, and so on, when it was. And that is the basis of the misunderstanding, and that on the authority and in my submission on familiar principles means that this court is both entitled to find UB Tiger per incuriam. Per incuriam wasn't used as reasoning in Star Wars.
Or is it a case of two? It's not.
It doesn't need to go.
It's not really conflicting. They're not conflicting decisions, are they?
They're not directly conflicting, but they are certainly conflicting approaches. They are conflicting as a matter of principle. They're not conflicting in their outcomes.
Yeah.
And we submit that on that basis, you are firmly in the territory of being entitled not to follow UB Tiger, to follow the approach in Seguros.
We don't gather to what extent Bristol Aeroplane and the cases following that were cited and considered.
Well, your Lordship could turn to your right to ask that, but I do submit that Bristol Aeroplane is a fundamental.
I think Young and Bristol Aeroplanes was cited. I mean, it's in the Chancery report, so the cases cited will be in there.
I'm not sure. I hadn't appreciated that. It is such a fundamental decision. It deprives belief, with respect, that wasn't firmly in mind. So we do rely on that decision. So, my Lord and Lady, unless.
So you're saying, perhaps somewhat in passing, we can distinguish UB Tiger because we're concerned with an injunction and they're concerned with this performance.
Yes.
you say we're not bound to follow it. I mean, you say it was wrong.
Well, yes.
For the reasons that you've given. And we're not bound to follow it despite the fact that it appears to conflict with Seguros, which it fully considered, because it's a conflicting approach, but it's not actually inconsistent. Do you actually say it's per incuriam?
Well, I would go that far.
In what respect?
It's per incuriam because, on the basis of my submission, that it misunderstands the test that it is applying. There is an evident...
So it's per incuriam, the proper understanding of Seguros.
And yes, and Spry and the approach. Per incuriam, yeah, precisely. Failing to understand the approach which should be applied in a case where equity is acting in an auxiliary jurisdiction.
So
it's not a case where that test was enunciated, all things considered. It was a test where it was applied in error.
So you've abandoned your inconsistent with the House of Lords. You've got conflicting decisions, but actually, you say, not truly conflicting decisions. Do you?
Well, look, I do say they're conflicting decisions in the most material sense, which is that the reasoning is entirely opposed. When one looks at, because Theodore Seguros was not simply saying this is exclusive jurisdiction, this is how we deal with it, this is the equivalence test. There's a wider analysis which is picked up and considered by Lord Justice Morbick in UB Tiger, which as it were sets out the wider picture. I've taken you through Theodore Seguros, and it does contain the distinction which is, we say, overlooked.
Yeah. Well, you also say, I think, that in UB Tiger, this court wrongly distinguished Knox and Guy.
Well, indeed,
which brings you sort of within star-mark territory.
Yes.
But there's another case called Holden and the Crown Prosecution Service, which is referred to in Iqbal, which is in our bundle, tab 13. Paragraph 61, I think it's the Justice Gage, refers to Holden. Says the court found itself able to avoid following a previous decision of the Court of Appeal because it disagreed with it, and quotes Lord Green, Lord Lane, rather. I think he says, he quotes Lord Wright, who's saying that he, that is Lord Wright, inclines the view that our duty is to follow the law as we believe it to have been laid down in the previous decision of the House of Lords.
Well, look,
i.e., not in our case, Knox and Guy.
Yeah. Look, I abandoned the direct route of saying that the decision was inconsistent with the House of Lords decision because, on the strength of Iqbal, as appears to be saying that there has to be a subsequent case of the House of Lords. You can't simply say the Court of Appeal was inconsistent with an earlier decision of the House of Lords, which was before the court, which obviously Knox and Guy was in UB time. And that's the basis on which I abandoned that as a direct route through to saying it's per incuriam. But that does not mean, of course, that I'm not making full reliance on what we say was the misunderstanding of Knox and Guy, among others, in submitting either that UB Tiger was simply per incuriam, or in submitting, but it's also highly relevant because it is part of the misunderstanding narrative that leads one to the conclusion that it's inconsistent with Theodore Seguros. Yeah. So I'm not at all withdrawing reliance on Knox and Guy and with the inconsistency with UB Tiger. All I was seeking to do was to simplify matters effectively, We don't need that, and it does appear from the case of a learned friend kindly produced that it has to be a subsequent decision of the House of Lords. Otherwise, the direct route, if I can put it that way, doesn't apply. So that's the limit of my withdrawal, as it were, on that front.
But Knox and Guy remains part of the warp and weft of what you are saying.
It does, indeed. Of course, it does. Indeed, milady. That's precisely the right way to put it. And of course, it's House of Lords authority, and it infuses, indeed, the subsequent cases.
Right. Well, that's your reply on.
That's my reply.
Lord. And you wanted to say something about the two-stage duty.
Yes, Lord. Can I do that shortly, I hope? The claimants, as I understand it, now make a distinction between the imposition of a statutory duty to supply a VAT invoice, which they accept must be provided within 30 days of the supply, and they distinguish that from the imposition of an actionable private law duty to supply a VAT invoice, which they contend should be aligned to the perfectly clear and workable concept of a reasonable excuse in section 69 of the VAT Act, so that the duty arises as and when the supplier has no, or perhaps more likely, no longer has, a reasonable excuse not to provide one.
Yeah.
Has no would mean, well, the duty's at the same time, because it applies presumably on the 30 days, 31st day, you don't have a reasonable excuse, so his actionable statutory duty arises at the same time as the duty is imposed. But in a case such as this, where he now says, well, there may be a reasonable excuse at first because everyone misunderstood the law, then it arises later on. Now, Lord, I won't repeat any of the points on which we rely as to why there's no positive indication in favour of any statutory duty at all here. I take all of that as read, and the many negative indications against the imposition of any duty. All of those points we say remain live in respect of this reformulated claim, and that ought to be enough to dispose of the argument on its own. But in addition to those points, we do contend that the reformulated, the asserted actionable duty is both conceptually unclear and also utterly unworkable in practice. In addition, it's unpleaded, and this may not be the biggest point because there could be a reformulation at this stage, but it is quite clear if one looks at the pleadings in Harrier as an example, tab 23, and I can take your lordships to it, lordship to it if it's relevant. Page 279, if one looks at paragraphs 35, 36, and 40, which are the pleading out of the domestic statutory duty case, there's absolutely no reference to this duty arising at a later stage, or that one of the constituents of the cause of action is there's no reasonable excuse. It's simply not in. And per contra, when one comes on to look at the Frankovich claim, paragraphs 48 to 49, that's where it's dealing with the European duty and a Frankovich claim for damages. There you see recited the fact that later on we had absolutely no excuse once the decision of the ECJ had come out in TNT1. But that's brought in there for that point because that's a separate constituent element of the Frankovich claim, manifest breach and so on. So where necessary, that point is pleaded for a different purpose, but it's not pleaded as any part of the basic statutory duty claim. Well, that's purely a pleading point, but it is a reformulation in the Court of Appeal of the way the case is being put. But in any event, in the first place, we say there is absolutely no basis for inferring a parliamentary intention to impose an actionable duty at the later no reasonable excuse stage, if I can call it that. That's simply not a stage at which, under the Act or the regulations, any duty is imposed on a supplier or in any way exists under the legislation to provide a VAT invoice. Because the duty is a duty within 30 days, Regulation 13.1. If it's not complied with by that time, then there's a breach on the 31st day. But there is no later statutory duty to supply a VAT invoice at some subsequent point, even if it can be said that there's no longer a reasonable excuse for not having provided one. The only breach of duty to provide one remains on the 31st day. And we say the confusion has been caused by seeking to staple together a statutory duty to provide a VAT invoice, which is in the statute, which could, in theory, be an actionable duty, although we submit for all the reasons we've given that it isn't. On the one hand, we're trying to staple together a statutory duty to provide a VAT invoice with an administrative penalty system administered by the revenue, penalising late provision of VAT invoices. And we say the administrative penalty system under section 69(1) quite clearly doesn't create any duty to provide an invoice. In fact, you're penalised, doesn't bring into existence a duty, a new duty to provide an invoice, and nor does the reasonable excuse proviso in section 69(8), which relieves from the liability to a penalty, neither does that switch off a duty which would otherwise exist. The two, duty to provide an invoice and the penalty regime, are fundamentally separate. And in any event, seeking to identify an actionable claim by reference to when the supplier might not have or might no longer have a reasonable excuse is, we say, a very long way from being perfectly clear and workable, which was how Mr. Cordaro described it. Because it means that built into the ingredients of the cause of action has to be the allegation that the supplier has no reasonable excuse. But I invite you to recall the wording of section 69(8). The reasonable excuse arises, I'll just quote it for present purposes, if the person concerned satisfies the commissioners, or on appeal the tribunal, that there is no reasonable excuse for the failure. So it's the commissioners, controlled by the tribunal, who are, under the primary legislation, to decide whether they are satisfied that there is a reasonable excuse. So if that was going to be incorporated into the test, if that was to incorporate it into an actionable private law duty, we would be right back in the territory of a claimed actionable duty whose content, or indeed existence, depends on a third party's views or actions, the HMRC, switching on or off the duty according to whether they were satisfied.
And possibly,
That is
possibly a fourth party's view of the third party.
Indeed, a fourth party's view of the third party. And that is right back in the Todd and Adams situation, where you will recall the fishing boat case, where they said it was a very strong indicator against there being an actionable duty that a third party could switch it on or off. The regulations could be disapplied. And we say, if one just asks for a moment what has to be pleaded in alleging a breach of the reformulated actionable private law duty, one can see that the workability, it comes under even more pressure, since the commissioners may well not, as in this case they haven't, actually imposed a penalty at all for late penalty. There is unlikely to be any actual decision that they're not satisfied there is a reasonable excuse. There won't be any actual decision of the commissioner saying there is no reasonable excuse in this case, except very occasionally, I suppose, but obviously not in this case. So would a claimant have to establish that no reasonable commissioner could be satisfied that there could be a reasonable excuse? That would be the normal public law approach to this court asserting that the statutory discretion could only be exercised one way. It would be some sort of Wednesbury test. No reasonable commissioner could find other than that there's no reasonable excuse here. Is that what has to be pleaded? Or is the court, is it this court, not the tribunal, not HMRC, is it to take over the decision of whether or not there is a reasonable excuse on balance of probabilities? That would seem to be an abrogation to a decision maker who is not, under the statute, meant to be the one who's satisfied, an abrogation by this court of the primary decision as to whether or not they're satisfied. And that would seem to be contrary to statute. So there would be difficult questions to whether what would actually have to be established. Would it be an administrative quasi-public law test of no reasonable commissioner could be satisfied? We say there couldn't be less than that. Otherwise, the court would be effectively taking over a discretion that doesn't apply to that. And finally, one does have to ask this, and have to ask Mr. Cordaro this. If the commissioners tomorrow write us a letter saying that they're entirely satisfied that we have at all times had a reasonable excuse for not providing VAT invoices to the claimants, and decide that either on the basis of the length of time elapsed, or the difficulty in now providing invoices at this stage, or indeed on the basis that it would be unfair and improper to issue VAT invoices to them, given all the ZIPFIC considerations. If they were to write that letter and say, therefore, we conclude that we're absolutely satisfied that you at all times had a reasonable excuse not to provide invoices, does he accept then that his actionable duty doesn't arise or can't be maintained? So on the face of it, his cause of action is now missing an essential ingredient, unless possibly he judicially reviewed that decision of the commissioners, that letter of the commissioners, and sought to quash it on the basis that it was an unreasonable decision. If it stood, it would stand, and there would be an ingredient missing. But I pursue that speculation because it does, we say, illustrate the incredible complexities of trying to build what is an administrative system of penalties, which is no indication that it is actually conditioning the duty itself to provide a VAT invoice. That remains at all times, do it in 30 days. If you don't do it in 30 days, you've missed the boat. It's a one-off duty. You breach it, you don't breach it. The penalty system is a different administrative system for the commissioners to encourage compliance, but it is not, shouldn't be taken as any indication by Parliament that it was seeking to create an actionable duty at some later stage. And one gets into very deep waters that I fear, unless this court made it very clear precisely what the duty was and how it would be dealt with, we'd end up back in the court or this court arguing about the nature of the ingredient of the duty and whether it was satisfied or not. Well, there's my submission.
Thank you. Mr. Kodara, first of all, do you want to say anything about star mark?
Oh, yes, indeed. But as my lord, I think, observed the other day, it was a surprising outcome. But secondly, it would appear that it can be explained on the basis that a process of wrongly distinguishing, one court of appeals wrongly distinguishing the decision of an earlier court of appeal is, in a sense, equivalent to or code for inconsistency. So Court B says of Court A, well, of course, that was a different story. And Court C comes along and sees that actually it was the same story. And what we really have here is a conflict. So I would submit that star mark can be fitted into the Bristol regime on the basis of wrongful distinguishing leading to conflict. But if it can't, then it's a one-off case, and a result was achieved through force of advocacy, which, etc., etc. So that's what I say about star mark.
Right.
Secondly, I am concerned that we as it were, leave the argument on UB Tiger in a place that is satisfactory both to the court and fair to my clients. As the specific performance point. Could your lordships just briefly look at the skeleton argument of Royal Mail? It's page 98 of the core bundle, page 98, and on that page, para 5. And para 5 reads, the reasoning of Lord Justice Morbick would apply also to a claim for an injunction because there is no direct equivalent remedy at common law, see Chitty. So we've, and I've made this point in a sense already.
Yeah, you say it's not really open to Mr. Herberg at this stage to say we should distinguish it on the ground that the remedy here is different.
I do say that. Now, if that's unhelpful, the only other thing I would say is we're content to be sent away and write something, but equally, my primary position is, as my lord has put it to me, if that changes, then we're obviously ready to be told the court will be assisted. So the concession hasn't been withdrawn. I'm slightly conflicted because this is a matter of law, and obviously the court will want to get it right and so forth. So the offer is there. If it becomes material,
Yeah. Yes, I think we will invite you to put in some written submissions, Mr. Cordara. Could you do that within the next 7 days, please?
Indeed.
And if you want a short reply to that, say 3 days later.
The following Monday.
Yeah.
Good. And then finally, if I can just reply briefly on what my learned friend said about the about my note. So I'm dealing with that. We are in agreement, it would appear, that the regime, the penalty regime, is conceptually different from the underlying duty. That's obvious. So we both start from the same place. Where one goes next is secondly to say, and this disappeared rather from my late friend's presentation, the statutory duty is always on. The public law statutory duty is always on. There's no switching on and off, fishing boat style. And that's the point at which we part company, because my late friend elided the actionable point, which was my stage 2, with the always-on nature of the public duty. So that's my second point in reply. And thirdly, the suggestion that one might get a letter from the commissioners and so forth, that's simply of evidential value. We've proposed the yardstick of Section 69 as a useful yardstick to by which to measure the point which was already in that second skeleton of mine, not properly flagged, which is that one has to look at considerations of reasonableness in terms of deciding at what point and in what circumstances Parliament would have regarded it as appropriate for there to be a private law action to enforce the always-on public law duty. And if the commissioners take the view they take, well, that would no doubt be heavily influential, but it doesn't bind anyone. It must be a workable test because it's a civil liability penalty test. Presumably it's being applied all the time in the tribunal. So those are my responses.
Thank you very much. Thank you both very much for your presentations. Well, there's obviously a lot to think about, so it will not surprise you to learn that we will reserve our judgment, particularly as we've invited further submissions on the limitation point. You will get drafts in the usual way, your opportunity to correct our spelling and grammar, but not our reasoning, and we would hope that in the light of the drafts you will be able to agree an order disposing of the appeal. If you can't agree an order, please make short submissions on the form of order in writing, and we will make the order that we consider to be appropriate. Thank you all very much.
Right.